The 16th Annual Judicial Symposium on Civil Justice Issues, brought to you by the Law and Economics Center here at George Mason University's Antonin Scalia Law School. We're delighted to have all of you with us today. We have a day and a half of 9 panels with experts from a variety of different fields talking about civil justice issues. We do, of course, at the Law and Economics Center believe that a well-informed judiciary, particularly those who understand economic analysis, have the tools available to them to make better informed decisions. And our goal across the next couple of days is to give you people who can provide information about emerging issues in civil justice as well as evergreen ones, and leave you hopefully wanting to continue that discussion both during the breaks as well as later this afternoon and again tomorrow. So thank you all for being part of this program. I want to get to the meat of the program right away, but before I do that, a couple of things to alert you to. I want to introduce our staff so that you know if you have any questions across the next couple of days, you are welcome to reach out to all of them. And I'll start in the back of the room with the Associate Director of the Law and Economics Center, Rebecca Thacker, who is with us for the duration of the program. And great thanks go to Ashley Evero-George, who is our Associate Director of the Judicial Education Program. Many of you have known Ashley for quite some time, and you might note that her title has changed. We're delighted that she has taken on this greater leadership role as the leader of the Judicial Education Program. And working with her are our events coordinator, manager, Heather Parrish, up at the front of the room, and our program assistants, Ian Spears and Andrew Lee Dowlis. So if you have any questions throughout the program, please do reach out to them. I neglected to mention, although I think I've met most of you at this point, I'm Donald Koshin. I'm the Deputy Executive Director of the Law and Economics Center, and really happy to have all of you with us for this program. And so I'm going to launch our first panel, and we'll get started right away. Let me give you, actually before I launch the panel, let me just give you a little bit of the logistics of how each of these panels will work, as well as about the program throughout the next couple of days. So most of you have found the bathrooms are down here into at the end of the hall, so if you just turn out here, go left. If you need the bathroom at any point in time, that's where you can find that. And we will have 9 75-minute sessions, including a session during lunch today. So each of these will have somewhere between 2 and 4 panelists, as well as a moderator. The panelists are being asked to give opening remarks. The moderator will introduce each of the panelists. The panelists will then give opening remarks for somewhere between 8 and 12 minutes, depending on the size of the panel. And then they'll have some intra-panel discussion. But we want to give plenty of opportunity for all of you to ask questions throughout the next 2 days as well. And so you'll see that there are standing mics on each side of the room. I would suggest that as you see the final speaker conclude their remarks, and if you do have a question, you think about gravitating toward one of those mics to get in line for those questions. Of course, there will be some intra-panel discussion before we turn to the audience questions, but this will give us a chance to flow pretty regularly if you start heading over to those mics shortly after the last panelist is done with their remarks. So that's how we'll work it. As you know, we do start every panel on its designated time in the schedule, so there will be breaks between each panel, but please be back in the room at the designated time after the 15-minute break and in a seat here in the auditorium, because we do want to get every panel started so that we can give it the full attention during the time allotted. So with that, let's turn to our first panel, which is on emerging issues in civil justice. We always like to start off with a survey panel that gets you started to know what is interesting in the field, what are some of the emerging issues that you should have on your radar, and what are some of the ways in which economic analysis plays out in each of those. And we are honored to have Justice William Mims as our moderator for the first panel. Justice Mims, as many of you know, is a justice on the Virginia Supreme Court. He joined the court in 2010. He just became a senior justice earlier this year in 2022. He continues to serve in that role now, but he's taken on some exciting new responsibilities at Christopher Newport University, where he is both teaching and running the pre-law program. At Christopher Newport, he's also teaching a very interesting course we were discussing last night about encounters with the Constitution to freshmen, and a COVID-19 and the Constitution course to upper level students there at Christopher Newport. And we're hoping that he's going to be sending lots of his students our way to be to be students here at Scalia Law. Justice Mims earned his JD at George Washington University and his LLM at Georgetown, and before serving on the bench, before serving on the Supreme Court, he was not only a delegate for the Virginia General Assembly, but also a senator in the Virginia Senate, as well as Virginia's Attorney General. In addition, he's been an adjunct here at the Scalia Law School, and he also is on our advisory board for the Judicial Education Program, and we thank you for all of the great advice and counsel that you've given us over the years. And with that, I'll turn it over to Justice Mims to run our first panel.
Thank you. Thank you, Donald, for that very gracious introduction and for the energy that you brought to the first 5 minutes. If the coffee didn't do it, your excitement certainly does. Now, I was told to make the introductions short because the full bios of our extraordinary panelists are in your materials. So I'm going to, first of all, say that we welcome Jeffrey Wyatt, who's a partner at Skadden Arps. And I want to tell you two things about him that might not be in those materials. First of all, both of our panelists are completely devoted to pro bono service. And Jeff Wyatt's service, I note, relates in many instances to disabled citizens, and my hat is off to him for that. Second of all, he is an expert litigator, but he's an expert at something else as well. I don't want to send you to your cell phones immediately, but during the next break, I want you to go to capitalcocktails.com. Capital with an A, cocktails.com, and you will find, along with 4,262 followers, that he can mix a mean cocktail. I don't know when he finds the time, but I intend to become one of his followers myself. We also have Robert Bob Peck, who's the president of the Center for Constitutional Litigation. He also is devoted to pro bono, and he is the past president of the Freedom to Read Foundation, the past chair of Lawyers for Libraries. And I want to ask a preliminary question, and then I'm going to take the mic back in order to talk very briefly about the topics you all want to talk about. But you were born in 1953 in Brooklyn. I think many of us know that something happened in Brooklyn in 1958, or it actually didn't happen in Brooklyn, it happened in LA, when the Dodgers left town in the dark of the night. My question is, have you gotten over that yet?
Yeah, I must say at that young age, it really wasn't that big a deal to me.
Was there somebody else from Brooklyn who you had an association with at that point?
Well, there was a Dodger that I was linked with a little later. I played for a Brooklyn Little League team that Sandy Koufax had played for, and I was a pitcher, and I was the first to break his strikeout record for that team.
And he still hasn't gotten over that.
So I hear.
So they want Bob and Jeff are going to talk about three things. They're going to talk, first of all, about personal jurisdiction, and I'm fascinated by that. Pennoyer v. Neff was decided in 1878, shortly before I went to law school, and I really haven't spent too much time on personal jurisdiction since then. They're going to talk, second of all, about last year's decision in TransUnion versus Ramirez, which relates to class actions and class certification. I want one or both of you to tell me how it is that the dissent in that case was Justice Thomas joined by Justices Breyer, Sotomayor, and Kagan. That's not a lineup you see very often. So one or the other of you, please give us that. Finally, they're going to talk about the Axon and SEC cases. That's SEC versus Cochran and Axon Enterprise versus Federal Trade Commission that will be decided this term. And it has both jurisdictional and constitutional issues. But I want to read from one of the reviews of what the court will be deciding. And it says, and I quote, "While the court is expected to rule only on the jurisdictional question, not on the merits of the underlying constitutional claims, The briefs against the government, get this, the briefs against the government tremble with excitement at the prospect that the court will eventually hold that Congress may not protect administrative law judges from personal or political reprisal at the hand of the president. Tremble with excitement and administrative law judges are terms you don't usually hear in the same sentence. So, Bob, how about, I'm going to toss it to you because we are trembling with excitement to know what's happening in that case.
All right, well, we are going to start with personal jurisdiction, and I wanted to start also by thanking the Law and Economics Center for inviting me to help kick off this conference once again. I enjoyed it tremendously, and I only regret that briefing deadlines will call me back to my office as soon as I finish this panel and won't be able to enjoy the other sessions. But personal jurisdiction has been an issue of abiding interest of late to the Supreme Court, and as a result, with more than a decade of new decisions, some might say it is an emerged issue. But Jeff and I agreed that it really is still emerging because in many ways, what the Supreme Court has done is made a hash of what they've said about personal jurisdiction, and there are rumblings that they're still searching for a rubric in which they can talk about it in a more sensible fashion, and that was indeed suggested in the most recent decision by Justice Gorsuch in a concurrence. Now, as Justice Mims mentioned, we started our personal jurisdiction journey in the 19th century with Pennoyer versus Neff, which had a rigid geographical approach to personal jurisdiction. And in 1943, the international shoe changed all that. And it's still considered the seminal decision on personal jurisdiction. In fact, the Supreme Court refers to it as conical. And what it did is it established minimum contacts along with notions of fair play and substantial justice as the measure of due process as it applies to personal jurisdiction. It inspired states to begin enacting long-arm statutes, and in 1957, building on international shoe, the Supreme Court suggested that modern transportation and communications will make it even easier to extend personal jurisdiction by the states. And what we saw was that beginning in 2011, the Supreme Court began taking quite a number of personal jurisdiction cases. And in it, they began a process of cutting back on the reach of state courts on personal jurisdiction. They divided personal jurisdiction into two categories, specific and general. General was an all-purpose jurisdiction, and so a corporation was subject to personal jurisdiction in the state as long as it was at home in the state. And the court said that generally means it's either incorporated in that state or it has its principal headquarters there. Specific jurisdiction, they thought, originally at least, would do the heavy lifting. It was more important and more frequent basis for personal jurisdiction, and what it meant was that the defendant themselves had reached into that state in some fashion, caused the injury, and as a result then is subject to that state's jurisdiction. Now, the cases the court originally received on these issues were very odd fact patterns involving Argentinian plaintiffs suing the German parent of Mercedes over terrorism against Argentinians back in their home and bringing the case in California. So it's easy to see how the court could look askance at those cases. And still, it was looking for some sort of defining basis on which to measure due process in those notions of fair play and substantial justice. In the Bristol-Myers case, they sort of found it, it seemed. They basically said that no longer was personal jurisdiction really about fairness as much as it was about federalism. And they found this federalism principle within the due process clause. And by saying it's about federalism, they basically were trying to prevent states from reaching out extraterritorially to cases that probably another state had a better and real claim on. And so in the Bristol-Myers case, for example, this was a consolidated proceeding under California law in which plaintiffs from California had sued Bristol-Myers, a distributor of the subject drug that was in California, but also included plaintiffs from other states that had taken that drug. And the court basically divided it by saying certainly there would be jurisdiction in California for the California plaintiffs where they received and took the drug and were injured. That's a form of specific jurisdiction, but not for the other plaintiffs who really had no connection to California. That brings us to 2 years ago, the Ford case. And this was the consolidation of cases from Montana and Minnesota, in which in each instance, the plaintiff had been injured in their home state, but the car was originally purchased in a different state. Ford contended that basically that car was not their extension of the use of that state because they either had to sue where the car was originally bought, where the car was manufactured, or in Michigan where Ford had its headquarters and its incorporation. And what the court said was unanimously, in a sort of cutting back on this narrowing of jurisdiction, they said that when a company serves a market for a product in a state and that product causes injury in the state to one of its residents, the state courts have specific jurisdiction to hear the case. So in each instance, this Ford car caused the injury in the state because the state had an interest in protecting its residents, its roads from these kinds of hazards. And because Ford serviced these cars in the state, they marketed the same cars, they sold the same cars in that state. In fact, they even had a recall that involved one of the cars in Minnesota, that there was jurisdiction there. So that brings us to this term. And this term, there is a case called Mallory, in which the question is whether a business registration statute in Pennsylvania violates due process because it essentially says that when you register to do business in our state, you consent to jurisdiction. And this is a case involving an individual who worked for a railroad. He suffered exposure to toxic carcinogens when he worked for them, but he worked for them in Ohio and Virginia, for a while in Pennsylvania as well, but his exposures were in the other states. And the question is now whether or not the railroad is subject to jurisdiction in Pennsylvania. In Pennsylvania, they've had the statute for nearly a century, and it's been upheld by the Supreme Court almost a century ago. But the claim is that this is not the kind of consent. This is not consent under the statute. And you have an interesting battle going on between the parties over both originalism, because if you want to look seriously at the due process clause, the due process clause really didn't say anything at the time it was promulgated about personal jurisdiction, or whether there's sufficient notice and real consent here. Excuse me. And so that issue is before the court. Now, there's several interesting briefs that have been filed by others than the parties in this case. A group of civil procedure professors have suggested that this is really not a due process issue as much as it's a dormant Commerce Clause issue. Whether or not this is really the court, the state of Pennsylvania essentially extending its requirements extraterritorially. You have one professor who has been influential on civil procedure matters filing a brief that says that, well, the Pennsylvania statute is not a true consent statute, And so therefore, this is not the case that you should be considering this issue on. There is a second case that the court is holding that comes out of Georgia called Cooper, in which Georgia has a true consent statute that the Georgia Supreme Court said was valid. And that's the case that you should be deciding this on. In the Georgia case, a tire was purchased in Georgia for a car from Georgia owned by a Georgia resident, but when it was driven in Florida, that's when the accident occurred, and the tire was the fault. So the question in the Georgia case is whether the consent statute for the tire company essentially exposes it to personal jurisdiction in Georgia. And I would contend that that is a better fact pattern on which to decide whether the state's police powers and interests for the sale that occurred in its state that caused injury to one of its residents might be a stronger case for this kind of decision. Now, we've known that the court has, in the past, looked at these issues, sometimes dig the case, dismiss as improvidently granted because it's not the case, but then later take up the case that they've been holding in light of whatever case they had accepted. So that's always a possibility here. I want to raise one other issue before I turn it over to Jeff, and this is a case of mine that I'll be filing a cert petition on next month. And this one doesn't deal with state jurisdiction as much as it deals with federal jurisdiction. In this case, the USS Fitzgerald, a Navy destroyer, was in the Sea of Japan when it was hit by a tanker ship that weighed about 4 times as much. As a result, it gashed the bow of the Navy destroyer. That's where sleeping compartments of sailors were. 7 died and another 43 were injured. Now, there are 2 bases on which to claim personal jurisdiction. One, the Constitution recognizes admiralty jurisdiction and basically gives Congress substantial authority to implement that. And secondly, there is a rule of federal of civil procedure 4K2, which exists at the suggestion of the Supreme Court. And what it provides is that when you have a federal cause of action in which there is no state court of general jurisdiction that has jurisdiction over the parties, then it allows the federal courts, any federal court anywhere in the United States, to take jurisdiction provided that there are substantial national contacts. And this case was filed in the Eastern District of Louisiana, where it found that using this rubric of only being specific or general jurisdiction, that this was an attempt to use general jurisdiction, but that the Japanese company that leased and operated the ship did not have its headquarters here, did not have its incorporation here, and so therefore there was no personal jurisdiction. We went up to the Fifth Circuit. A panel of the Fifth Circuit agreed with my argument that this effectively tells everyone that that the rule 4K2 is unconstitutional as a matter of due process because it could never be applied, since it requires that no state court of general jurisdiction have personal jurisdiction over the parties. And so it therefore makes it impossible for you to invoke it in any instance. The panel agreed with me, but had an adverse precedent in which the issue had never really been argued. So they recommended that the court take it up en banc, and then we had a decision that went 12-5 against me. And in this instance, they said, well, it doesn't necessarily block out 4K2 in every instance because they cited 4 cases, one that preceded 4K2, but 3 of which involved where the foreign company brought itself into the United States and so therefore was subject to jurisdiction on a specific jurisdiction basis. The problem with those cases is that no one recognized that if you have specific jurisdiction, that means some state court also has jurisdiction. And so those instances do not actually undermine my theory that this basically tells Congress and the courts that by promulgating 4K2, they promulgated something that's unconstitutional. So given the fact that we're under the Fifth Amendment rather than the 14th Amendment, and the Supreme Court has reserved what due process means under the Fifth Amendment in the Bristol-Myers case for a later decision, and how that might also influence subsequent interpretations of the 14th Amendment, not only does my case have the potential to change the personal jurisdiction measures, not just at the federal level, but also at the state level, but the court's interest expressed in Ford for trying to find a different rubric for this. Gorsuch even suggested that international shoe itself should be reexamined. We suggest that this is still an emerging issue that's likely to affect both federal and state courts.
Thanks, Bob. That was a great explanation in both cases, and I'll add a little bit to both those points, and then we can sort of move to our next topic to keep on track. But one thing that links these two cases, I think, is this question of burden, and particularly burden on foreign defendants. One interesting aspect of the Mallory case is that the Solicitor General put in an amicus brief unsolicited in this case in support of the defendants. And one of the issues that the Solicitor General raised was what is going to happen, or what is the impact going to be from a foreign relations perspective on foreign defendants that may, by virtue of doing business in Pennsylvania or any other state that adopts Pennsylvania's business registration statute, and perhaps if it's upheld here, all 50 states would do that, you would suddenly essentially have general jurisdiction over all corporations, domestic or foreign, in those states. And there's a flavor of that, I think, or at least it's in the background of the Douglas case. How do you draw these lines around if you're going to adopt a different approach to personal jurisdiction under the Fifth Amendment in cases involving foreign defendants or in cases involving, I mean, these are necessarily, I think, international cases we're talking about, because it's a situation where there wouldn't be jurisdiction in a state court. Where do you draw those lines? So it'll be interesting to see if the Solicitor General also enters a view or an amicus brief in your case as well. The other sort of principle, I think, that is behind, though, the Solicitor General's position and sort of the issue I just raised is just this idea of burden in general, which you can see is animating a number of the Supreme Court's recent decisions in this area. Federalism is something that entered the fray with a little more prominence in BMS, for sure. Although Judge Jones, in your case, Bob, sort of said federalism is really just another way of saying burden. It's derivative of burden, I think, is the way that she put it. I don't know if that's totally fair, but you know, speaking from a defendant's perspective, there was a time when plaintiffs in mass tort litigation in particular could just file all their cases in Minnesota and get the advantage of the 6-year statute of limitations there because of, you know, the fact that the defendant marketed the product everywhere. So there's no sort of unfairness in having to defend a case in that state. I do think it's a little more rational to have a requirement of some connection of that particular case to the forum. And I think the Pennsylvania case, at least, really puts that question back to the fore. It does seem a little superficial to be able to circumvent that whole, 10 plus years of jurisprudence at this point by simply saying, well, you registered to do business here, so you've sort of waived your rights. And I think, it is an interesting question. What is the doctrine that's actually at issue in Mallory? Is it personal jurisdiction or is it something else? And I think there is a flavor, certainly, of the arguments that it's an unconstitutional conditions case more than a straight-up jurisdictional case, because you are being asked to, in the defendant's view, to waive your, constitutional due process rights as a condition of doing business in the state. I guess the last thing I'll say about these cases is, in both cases, again, the current of originalism and how it plays out is really fascinating in both cases. personal jurisdiction has changed a lot, as Bob recounted, over the years. So it's sort of hard to conceptualize jurisdiction purely from an originalist perspective, especially when communication, travel, all those things have changed so much over the decades. But it's definitely there to sort out in the Mallory case, because the older precedents that are being cited there in support of this registration statute are 100 years old. They're from a time when there was no long-arm statute, and so you had to sort of create these tools to get jurisdiction over out-of-state corporations in a way that you really don't have to do anymore in a case where there actually is some nexus to the forum. So a lot of interesting issues in these cases and a lot of overlapping, I think, conceptual points.
Yeah, one interesting other aspect that I think is worth mentioning is the facts behind International Shoe itself, because that too actually turned on registration. We often think about the standards set by International Shoe, but this was Washington State trying to collect taxes on sales that were done by a shoe company that had no real presence in Washington State. And so it was those facts that justified Washington suing within the state the shoe company in order to collect those taxes. So just an interesting other fact that's part of the mix of how we think about personal jurisdiction.
Would you like to talk about class actions next?
And particularly that Thomas dissent. It's got to tell me how that happened.
So I'm not sure I can speak to that, but I do think there's a lot of interesting issues coming out of this precedent. Maybe Bob's got an answer for you on that one. So just to set the table, the TransUnion case involved an issue that has been sort of a favorite of defendants, but one that defendants had not got much traction on over the years, which is, does the entire class have to be injured? And if so, to what extent do you have to prove or establish or plead that at various points in the case? It has not really been a winning argument over the years that you shouldn't certify a class because there may be some difference in the way in which or the extent to which people in the class are injured or allegedly injured. And courts typically say, well, this is a damages issue that you can sort out later. We don't need to hold up class certification on that ground. TransUnion did not, by itself, turn the world upside down on that issue, but it sort of did actually give a nod in that direction that I think is changing class action practice a little bit. So just to remind everybody of that case, or to educate if you haven't read it before, in that case, the plaintiffs argued the TransUnion, a credit agency, had injured them under the Fair Credit Reporting Act because it had put erroneously something called an OFAC name screen alert in their credit file. And this is basically, the allegation was, TransUnion got a list from the Treasury Department. It matched the names of the people it had credit files on with names on this list of terrorists, drug traffickers, other serious criminals. And if the names matched, it would put a flag in the file without further diligence. That was the allegation in the case. And so you can imagine John Smith, if John Smith is on the OFAC list, there's a lot of people who probably shouldn't have flags in their credit files who did, is the theory of the case. It's also an interesting case because it's a rare case where there was a trial. Class actions almost never, ever go to trial, but this is one where they did. And it was stipulated prior to trial by the parties that of the class of 8,185 individuals, only 1,853 class members, or a little bit less than a quarter of the class, had their erroneous OFAC alerts provided to some other party. And so the question in the case is really, well, if you have a flag in your file, no one's ever seen it, tree falling in the woods without anyone around, are you injured? The answer is no, according to the Supreme Court. You are not injured. It's not a concrete injury. So the court sends it back to the Ninth Circuit to figure out what to do next. It doesn't answer the question, expressly does not answer the question. It has a footnote saying we are not answering the question, the distinct question whether every class member must demonstrate standing before a court certifies a class. But it's fairly obvious that some work has to be done in that department, or else you're going to end up in the same place. In all cases, all roads are going to lead to Ramirez. You're going to end up with a class trial where there's, an obvious problem in terms of the scope of the injury, and you're going to have to go back and sort it out. So a number of cases have spoken to that issue after Ramirez. What do we do about this? How important is injury? Does it change anything? And there's a couple of cases percolating right now that I'll summarize quickly that kind of bring that issue to the fore. The first is Starkist versus Olean Wholesale Grocery Cooperative, which is a Ninth Circuit en banc decision. This is a case about tuna suppliers. There was a government investigation that came to the conclusion that there was a price-fixing scheme among tuna suppliers, and as often happens in the class action space, a private class action followed shortly thereafter on behalf of a number of subclasses, including direct purchasers like grocery stores and retailers. And the plaintiffs brought in experts, not surprisingly, saying everyone's injured, everyone paid too much for tuna. And the defendants, also not surprisingly, had an expert who said, no, not everyone. Some people have more bargaining power than others, and not everybody's injured because not everybody got the same deal. And the Ninth Circuit en banc affirmed class certification, and it said, look, the plaintiffs have evidence that, if believed, show class-wide injury, so we don't really need to sort this out. This is a question for the jury to sort out. Even if it weren't, the jury can always decide some of the class is injured and some of it isn't, and we can sort that out later. Individualized damages, as courts always say, are not a reason to deny class certification. But there's a dissent from Judge Lee and Judge Kleinfeld, which says a couple of things, three things that I think are really interesting, some of which are issues that have been kicking around for a while in the class action space, some of which are new. Number one is that the courts have to conduct a rigorous analysis at the Rule 23 stage. And that's what Walmart versus Duke says. And that means even resolving conflicts between experts that feel like merits decisions, because if they go to whether common issues predominate, you can't save it for later. The jury can still evaluate those issues later, but you have to make a decision as a judge on the Rule 23 question. It's not just a matter of, is it admissible under Rule 702, or would the evidence, if believed, establish injury? You actually have to show, as the proponent of class certification, that you are correct by a preponderance of the evidence that it is class-wide injury. On the issue of whether you can just kick individualized damages issues down the road, as courts often do, the judges said, that's not exactly right. It oversimplifies things. What we mean is, if it's a simple formula type damages calculation, it's different, yes, but it's just doing the same calculation over and over again. Those you can kick down the road, but where you actually would have to make class member specific inquiries, such as whether they have enough bargaining power to avoid injury, that's a different story. And then same thing with respect to saying the jury can decide for itself whether the scope of the injury is class-wide or not. That conflicts with the approach other circuits have taken, which, following Ramirez, say you can only tolerate a de minimis number of non-injured class members before you have to deny class certification because it's an individualized case. There's a cert petition pending now in that case. The response is due tomorrow. So we're right in the middle of it. But it really, those three issues bring kind of into focus the work that is left to be done after Ramirez, both in terms of deciding how much is enough, in terms of the breadth of the injury in the class, how do you prove it, what role do the courts have in deciding those issues. And I'll flag too, there's one other case pending now in the DC Circuit, National ATM Council versus Visa. Very similar questions raised. Did everybody pay the extra fees at the ATM is in essence the question. And it's the same construct. Plaintiffs have an expert who says everyone's injured. Defendants have an expert who says, well, not everyone. And so, again, how do you sort that out? And I think it'll be really interesting to see if the court takes the case, number one, doesn't have to take the case. But I think there's ground for it to do so because it seems like the courts are a little bit tied up in this space.
So I think thinking about the TransUnion case, it's useful to step back for a moment and understand the underlying facts. Sergio Ramirez, who is the named class representative, went to buy a car, and his credit was rejected on the basis of a report from TransUnion. And TransUnion basically reported that he was on a U.S. Treasury terrorist list. And under the law, credit is not extended to those people, except that he was not on that list. He just had the same name as someone who was on the list. And that was true of all the other putative class members. And so that's the basis of the lawsuit. Now, the majority, it's a 5-4 decision written by Justice Kavanaugh, basically rejected the argument that Congress could convey standing without determining damages. So they made no mention of how damages are determined or assured that damages are determined. And so that was the question for the court. Now, interestingly enough, in Worth versus Selden in 1975, the court observed that Congress may create a statutory right or entitlement, the alleged deprivation of which can confer standing to sue even where the plaintiff would have suffered no judicially recognizable injury in the absence of the statute. But what TransUnion did was adopt a history and tradition approach. And by doing that, they said basically there was no history or tradition in the common law that essentially allowed this kind of lawsuit to go forward. And that has large implications, not only in the class action realm, but beyond that too, because there are many federal statutes that recognize standing without denominating damages. Now, this is what caused Justice Thomas to write one of the principal dissents, the principal dissent. And that is, he's basically tried to carve out a very consistent approach to these issues. And in the past, he has taken the position that statutes create legal rights, and the courts have no business in saying that the statutes can't do that unless it violates the Constitution. And here he said that there was no reason to say that. In fact, he says, the invasion of a statutory legal right creates standing. And that is one of the principal points of his dissent. But there's also something for those of you in state courts in his dissent. And he says, this may be a Pyrrhic victory, because if there's no federal standing to do this, states often have much more liberal standing provisions. They don't necessarily require the same concrete injury in fact. And as a result, these cases will then go to state courts, and the state courts will have to deal with it. And there is no reason when Congress essentially sets up a right of this nature that it always has to go to state court. So that's essentially the view that he is putting out there that was joined by the other justices that are not normally aligned with him. And I think that explains his approach to this dissent. And the other thing about this history and tradition issue is it really will become an issue for each statute that Congress passes, where they create a private right of action without telling the courts what type of damages should be had. And so unless they develop at least liquidated damages or some other damages, it seems under this decision that Congress will be hamstrung, and basically, if it doesn't learn the lesson from this case, it's many current statutes, as well as many future statutes, could be in jeopardy. Anything further?
No, I'm just glad that you had the answer to the question. I don't like to leave a justice's question hanging,
You both know infinitely more than I do on this topic, but I am trembling with excitement for the third.
And so for the trembling with excitement issue, we have the Axon and SEC versus Cochran cases. In both these instances, the companies were being investigated by a federal agency. Axon makes personal body cameras for law enforcement and acquired a competitor at one point, and the FTC basically notified it that unless you do the following, we're going to bring an antitrust investigation against you. Now, normally, what happens under the Administrative Procedures Act is that the agency does its investigation. There may be issues that are then brought before an administrative law judge. And if the party is unsatisfied with the result, they have an opportunity to appeal it to the courts. Axon, just like in the SEC v. Cochran case, decided to bypass that and to bring in action, an original action in the district court challenging the constitutionality and structure of the FTC or the SEC in the other case. And basically, they said that when you have appointees under a recent Supreme Court decision that are not subject to the control of the president, they are not subject to being fired by the president or such, then they are essentially an unconstitutional structure. And this is the structure that we have for independent agencies. So they're trembling with excitement because this is, in sort of the most broad sense, an attack on the New Deal. But as that statement that you read stated, this is just about whether or not there is subject matter jurisdiction to go to federal court to challenge the constitutionality of the agency structure this way, or whether you have to await an administrative decision, essentially exhaust those administrative remedies. In 1983 actions, you don't have to exhaust it. If there's a constitutional issue, there is no reason to exhaust it. It would be futile to go through the administrative procedures to do so, and that is what the corporations are arguing in this instance. This is the same basic deal. But the fact is that if this is the case, what we're going to see is a flood of actions challenging various administrative agencies and the use of administrative judges, which has always been thought to be something that once Congress fixed it after the last Supreme Court decision is beyond question. It apparently is not.
Yeah, I mean, it's a really interesting case, the trembling with excitement. It's not really as I mean, it contains a substantive attack underlying these cases on the administrative state. But the question for review is only whether we can hear it in this fashion or whether we have to do it the old-fashioned way. But there is still an element of an affront to the administrative state in the sense that it is clearly openly questioning whether we should be trusting, really, administrative agencies to handle this in the first instance, whether you think it's because they'll get it wrong, which, you might think agencies would be inclined not to rule that their, own procedures are unconstitutional. There's definitely a flavor of that in the briefing. And also because it does delay, I suppose, if you're in a hurry, which it seems like some people are, that's the trembling excitement, to get your challenges heard. It can take a while because, not only does the administrative agency process sort of delay your day in court, but it also may mean you never get to court because you could win, heaven forbid, in the agency process, or you could settle it, or something else could happen that would moot the case or take the question otherwise away. So, it is interesting, I mean, especially in the context of a court that seems more interested than any court in recent history, certainly, in raising questions that I think a lot of people have long thought are settled about administrative law. This is not the first volley, but it's sort of one of the early volleys in that war, I think. And so that's another reason why I think there's a lot of attention here. It's hard to know from where I'm sitting, hard to predict how the Supreme Court's going to deal with this, not only because we've only gotten a few rulings in this area, but also because just the posture of the two cases. When I originally looked at this, I sort of thought, well, it's a little weird the court granted review in Axon first, given that Axon was sort of the ruling for the status quo, sort of what's changed, right? But then you dig into it, and it's clear that that really tells us nothing, because Axon was granted after Cochran was decided, and so you had a split at that point, and you had an absolute need for Supreme Court review. Because you can't really have two different rules operating in the country at the same time around this issue. And in fact, the Axon parties have been watching the Cochran case very closely, as one would because Cochran in the Fifth Circuit had originally gone the way that the Axon case had gone, but then an en banc petition was granted. And so suddenly everybody's on alert, like, oh, something might happen here. And in fact, something did happen, and then the Axon parties put in a brief, the Axon petitioners put in a brief saying, see, you need to grant cert. The government said you would have to if Cochran was decided the other way, and it has been. And then shortly after, the court did, in fact, grant cert in that case about a month later. So hard to read too much into the fact that the court has granted review there. It almost had to do it in this circumstance. It does not, I don't think, necessarily signal that the court is going to turn the world upside down. But, you know, there are signs that it could, which makes it a really interesting case to watch. And we'll have to see how that goes. In terms of the immediate consequences, if the Fifth Circuit approach is adopted here, I think you're right. I mean, you'll see more challenges because they'll be more easily made. What items the sort of anti-administrative state folks have on their list, I'm not totally sure, but I imagine it's more than just the removal power. And you know, they may be able to accelerate getting those heard. Institutionally, I think one of the questions the court will have to think about, and certainly is in the briefing on this, is, you know, piecemeal litigation, kind of having to fight on two fronts at the same time, both within the agency and out in district court on whether the agency actually has the authority to hear the thing in the first place. It's going to be a lot more expensive for everyone, the government and the litigators both. It kind of, when you think about parallels or analogs, you know, runs afoul of some of the rules we have against piecemeal review, abstention in certain circumstances, although that's more, I think, a doctrine that reflects the comedy concerns due to the states that I'm sure some folks will not think are due to federal agencies. So I'm not sure that parallel will hold up. But I do think a lot of those same policy concerns are there. So a lot of stuff to weigh in these cases, and very difficult to predict, given how things have changed at the high court, how that's going to play out.
Right. I do agree that it's going to be difficult to predict. It's going to be a close vote, but I also think that it's unlikely that all justices will hold back on their thoughts about the ultimate question about the constitutionality of these agencies. So we're likely to see either a concurrence or a dissent that lays out the case against the administrative state in this fashion, which will no doubt encourage further litigation. The other aspect of this that I think is important for civil justice also is that if the agencies can't act internally because of some problem with their structure, what it will encourage is more private litigation enforcing these kinds of regulations.
So I want to follow up about the administrative state aspects that you just mentioned. That term sometimes drips off the tongue. And I'm wondering, can we look at the major questions doctrine debate that occurred recently and to find any sort of hint about what might happen in this case, or are they totally different? I'm wondering, is there in fact going to be a frontal assault on agencies?
I mean, I think it's hard to ignore it, right? I mean, it's a different issue, but I think that a lot of it has to do with trust or lack of trust of agencies. You know, the undemocratic is, if you're adopting the verbiage of the antagonist here, you know, unaccountable, bureaucratic sort of machine that's out there. I think that will play into, or could play into, a decision saying, well, why are we shutting the door to the courts on kind of fundamental questions about whether the agencies are properly constituted or have proper procedures or whatever. I mean, I could absolutely see that sort of worldview translating from one case to the next.
And let me just add that, you know, all this case does is decide whether that issue is up front and center now or later.
Substantive issue.
Right.
Yeah.
If there's no jurisdiction in the district court, they simply have to await the completion of the administrative process before they can launch their constitutional attack. But obviously, if they can bring this up in the district court, then it's front and center right now. I think that you know, recent decisions concerning the Consumer Protection Board and others have encouraged corporations, when they don't like what the possible result is, to seek this kind of a remedy. And even if they are not successful in the end, you know, there was a litigator who once represented IBM in an antitrust case, and he said, you know, bringing dilatory tactics are in my favor because the market will change, and it did in the 1969 IBM antitrust action, and as a result, that worked for my client.
Indeed, it did. Now, is it based upon the questions that have been briefed? This is coming up in November. I mean, this is coming up like 2 or 3 weeks. Is it indeed possible that the substantive issue, that if jurisdiction is found, that the substantive issues are squarely addressed in a majority opinion, or should we truly be looking to a dissent or a concurrence for next year or the year after?
I sincerely doubt it. And the reason I doubt it is because that would be the court really reaching for an issue that hasn't been fully briefed. And at least my experience with the court has been that when they do want to do that, they ask the litigants to come back, rebrief it, and re-argue it the following year.
Okay, all right. Well, I've already asked my 2 questions, so are there other questions that you have? First of all, and thank you, by the way, for 3 fascinating discussions, truly from experts in the field. Let's give them a hand right now, first of all. And then are there questions?
Well, I'll ask Bob a question if you don't mind.
Oh, absolutely.
So
If he can ask you one back.
Bob and I talked about the topics to discuss on this, and he raised his Fifth Circuit case on personal jurisdiction. And the first thing that came to my mind was, well, it's the Fifth Amendment has a due process clause, 14th Amendment has a due process clause. They basically say the same thing. How could they possibly be different? This must be like the easiest decision in the world. What I think Bob may have left out is that there was like 104 pages in this decision. I think there were like 6 different opinions. There was one footnote that was more than a page long. Can you tell us a little bit more about why the Fifth Amendment approach to personal jurisdiction, or just how it's different from the 14th? Because I think that there's a lot. I mean, it's a really fascinating read if you're into jurisdictional issues, this opinion, because everybody's got a view and they feel very, very strongly about it.
So those of you who practice in state courts understand that state constitutions that even use identical language to the federal constitution do not necessarily mean the same thing as the federal constitution says. And that's in part a product of the understandings that surrounded that provision when it was put into the state constitution. And so those are differences. So the Fifth Amendment, promulgated in 1791, had different understandings about due process than necessarily were common among the Congress when the 14th Amendment was promulgated in 1868. And that is a significant difference that has been written extensively about by Professor Stephen Sachs, who is an originalist and who is cited in the opinion by the dissenters. And there's an interesting back and forth among 2 concurring opinions about which side took the real originalist view. But that's part of it, and certainly, as Sachs makes clear by looking through it, that there was no indication that this new national system would somehow be restrained by virtue of this. And the fact that this also takes place against the background of the law of nations admiralty. We cited, for example, in our Fifth Circuit briefs, a decision of John Marshall in which a Belgian ship crashed into an Argentinian ship in the middle of the Atlantic. And Marshall found no problem in exercising jurisdiction over the case and deciding the liabilities there, which was a function in part of the admiralty jurisdiction, but also recognized no due process issue of any kind. And that, we think, is part of this decision about why the Fifth Amendment did not reach there. And if the 14th Amendment is about federalism, as Bristol Myers tells us, then The fact is that comedy is almost the only question on the international scale, and that tends to favor our position because of the practice at the time that the Fifth Amendment was promulgated.
So I have to ask, tongue-in-cheek a bit, in light of current partisan political debates, you mentioned that there were two concurrences about which one is the more originalist. Are we going to see the court calling each other "oh-I-knows," originalist in name only?
I'm not sure I'd expect that specific term to be used, but it certainly was the flavor of the competing views in the Fifth Circuit, and I wouldn't be surprised that a similar flavor might not emerge at some point.
It's either Justice Kagan or Justice Sotomayor who said we're all originalists now, and I guess we are.
Well,
although I'm not sure that that had the same meaning.
I think she said we were all textualists now.
Oh, okay.
But obviously, still being a textualist, there seems to be some wide variation.
Now, other interesting question that I was wondering about, if there is no jurisdiction in a United States federal district, where can the case be? Does it have to go to Japan?
I was gonna ask the same
That's the
question.
contention of the defendants.
Okay. And what flag was the ship flying?
The tanker.
The tanker, yes.
Japanese.
Oh, okay. All right.
Yeah, and that's the other interesting thing. This was a U.S. warship, and a U.S. warship is an extension of U.S. sovereignty wherever it is.
Yeah. Interesting. Yes, yes, sir.
So, can you guys hear me okay?
Yeah.
Okay. I've been a trial judge in Texas for the last 16 years, and I've seen we handle just civil jurisdiction in my court. I've seen a lot more challenges over the last few years to personal jurisdiction. I had a case recently where a defendant argued that international shoe has been completely overruled by these recent cases out of the U.S. Supreme Court. What is the panel's view on that?
Well, in every decision when the court talks about personal jurisdiction, they still talk about international shoe as canonical. So they're still at least giving it the lip service of recognizing that it really is the seminal and controlling decision, even if they are looking in different directions. So I would tell you that the Supreme Court has taken the position frequently that no decision of their court is overruled until they specifically say so, and that lower courts are obligated to follow their decisions until that happens, even if they question a decision in one of their opinions.
Yeah, I would say the international shoe, clay, had some molding left to be done. I think it's probably the way to think about it, at least, without taking the cynical view that de facto it's been overruled. I mean, practice has definitely changed. I alluded to it earlier in the mass tort bar. It was not uncommon at all before 2011, before Daimler at least, to be a product liability defendant defending, an Arkansas plaintiff against a Pennsylvania manufacturer in Minnesota, because they waited 5 years to bring their case, and that was the one jurisdiction in America where they could still do it in a timely fashion. That has definitely changed. I mean, BMS squarely says you can't do that. Ford softens it a little bit, but Ford still requires some connection to the forum. The accident had to happen there. I think there was just, there was a lot left to sort of be decided in that space in terms of what an international shoe really mean. Now it has been decided, practice has changed. I don't think it really overruled shoe, but it did overrule some practices that had grown up in the absence of a more refined take on what it meant.
One other jurisdictional question, and this arose in my court several years ago, and I don't recall the precise issues, but Yelp, there were negative reviews that were either anonymous or had come from somebody using a fake name. And in fact, it was here in Arlington, I believe, the entity that was harmed. And then the question became, when you don't know who the defendant is, or you have to sue a John Doe for an internet-related crime, where is jurisdiction? And I'm thinking that's something that all of us are going to face at one time or another. Do you have any guidance for us?
Yeah, that's a tough one. I mean, I would think that the plaintiff experiencing injury in Arlington would be on safe ground suing there. At least in a Yelp case where the person putting the review on there can reasonably expect to damage that entity in writing the review. But that's a really interesting question. And the internet stuff, I mean, there's a lot of internet-related personal injury cases out there, and they are all over the map. I mean, I don't know if it's because there's not a coherent doctrine around it yet, or because every case just has different facts, and that explains it all. But it gets difficult very quickly.
Yeah, and I think, in fact, in that instance, there was a desire to do discovery of Yelp in terms of who was the person or people who put the review on. And Yelp is a California corporation, if I recall, and they weren't real keen about coming into Arlington Circuit Court and responding to discovery. So
I would have suspected as much. And, it raises a lot of different issues. There was a case that the Supreme Court turned down that was decided by the Texas Supreme Court, which raises a few of the kinds of issues that the internet raises. And this one really had to do with a Mexican television station that broadcast something very unfavorable about a former soap opera star from Mexico, but who was now living in Texas. And she sued the Mexican station in Texas, and the question was whether or not there was jurisdiction over that station. And she was able to get jurisdiction not over the fact that through the airwaves, Southern Texas gets that station, but because the Mexican station sent salespeople into Texas to sell ads and air them on the station, that was enough of a connection that allowed the personal jurisdiction to be asserted. To date, as far as I know, there's been complete resistance over saying that the fact that your internet options are essentially available in every state allows that state to have jurisdiction. But I think that is an issue that there's going to have to be some sort of standards, because it's going to be increasingly so, especially given the fact that the First Amendment protects both anonymous and pseudonymous speech, the Federalist Papers being a great example of that.
Mm-hmm.
Yeah, it is tricky. There's that layer there. I mean, in this instance, the Arlington case you described, there's sort of the injured party is in Arlington, and there's some nexus there to a particular forum. But I agree with Bob that the courts have been resistant to the idea that because you have an international reach with your broadcast, be it via internet or some other means, you're suddenly amenable to personal jurisdiction in every jurisdiction where it is broadcast. There has to be more of a nexus than that the cases have held so far. And I think it comes from the same concern that you see in the Mallory case of being cautious about creating sort of a general jurisdiction escape hatch or hook or something like that simply because you're in the internet business.
Mm-hmm. Other questions? Donald.
So in light of the number of state judges who are in our audience, can you talk a little bit about where the court is in terms of federalism concerns related to jurisdiction? In part, how much of this general jurisdiction fear is animated by a concern about preserving the space for state judges to still hear cases, as everything could get swept up in the court as an unintended consequence of some of these registration statutes that states might do. You've also pointed out the idea that there will be a race to everyone, having the same kind of registration statute, which they think state legislatures might think puts them in a good position to now hear cases in state courts, but ultimately the result may be that everything just gets channeled to federal courts. So how is the court considering these days in the jurisdiction space issues of federalism and the preservation of a space for state courts?
Well, in Bristol-Myers, Justice Alito wrote the majority opinion in which he did say that federalism was the principal animating rationale behind limiting personal jurisdiction, but that was a specific jurisdiction case. And there basically each state had certain concerns for its residents who were injured in that state. When the Ford case came up, the court somewhat moved in a different direction and broadened that. Again, the cars were purchased in one state, they were resold as used cars, eventually ending up in the states where jurisdiction was claimed. And that's where the injury occurred. And the recognition was that Ford basically was selling this car throughout the country, had a substantial presence in each of these states, that the state had a logical and proper concern with the safety of their roads and their residents. There is the second paragraph of the decision, which came out of an amicus brief that I wrote because I was the only one who mentioned this, is that Ford also had a website that said, "Keep your Ford a Ford," and urged Ford owners to buy original equipment manufactured parts, whether they did it themselves, whether they went to a dealership, whether they went ahead and found an independent auto shop. But the fact that Ford was basically continuing its relationship with its car wherever it went, I think made a big difference there. That is, I think, part of what this federalism calculation is going to be, is that how much is there going to be a connection? Now, we're entering a world of smart devices where there's a continuous connection between manufacturers and the device. They do over-the-air updates. They have constant connections to the devices. That, I think, is also a future issue that may suggest a different kind of approach to personal jurisdiction.
Yeah, I guess one other thing I'll say is, when you remove this ability in tort cases anyway to sue defendants in whatever of the 50 states you choose, you're down to 2 states, maybe 3, right? The home state or states of the defendant for general jurisdiction purposes, or the site of the tort, which is typically one state. And, the case, if you bring it against the manufacturer in the manufacturer's home state, you can do that in state court and keep it there if that's your preference. Whereas if you're sort of, the menu is all 50 states, removal is more easily accomplished based on diversity of citizenship. So perhaps that drives a greater share of the overall cases to state court. It's not really something the Supreme Court, I don't think, has ever spoken explicitly about in these cases, but that may actually be the effect of the narrowing or the, making clear how specific and general jurisdiction work.
And one other thing, if you translate some of the issues from my U.S. Navy case to a state, the defendant in that case maintains a U.S. headquarters in New York, which they've had since 1926. They have thousands of employees across the country. They specify in their bills of lading that jurisdiction over any dispute over the bill is in the Southern District of New York. Those types of connections, if it were a domestic corporation in a state, I think also support the kind of approach that the court took in Ford, which makes federalism secondary.
Okay, this truly has been fascinating, and I can't wait for these decisions to come down. I mean, if I go on CNN or Fox or somewhere, they're going to be talking about some other cases, but I'm going to be looking for these throughout the year, and will thank you when they come down.
I can see that you're trembling with excitement.
I am trembling with excitement indeed.
You can't see it because we're up here at the table with them.
Let's have another hand for this excellent panel.
Thank you very much to Justice Mims and to Bob and Jeffrey for a wonderful start to our program. A couple of quick announcements before we move to the break. As many of you know, that we're coming up on our 50th anniversary of the Law and Economics Center. So we were founded in 1974. We've been at the law school here at George Mason since 1986. And so we're very excited that you're here for this program in our building and have a chance to really see what's grown here at George Mason University's Antonin Scalia Law School. And I hope you'll take part of the break to explore the building. There's our Scalia statue is down at the end of the hall as you go out here. That it was crafted by Greg Wyatt. And if you turn left at the Scalia statue, there's a Wyatt gallery of some other wonderful sculptures that that Greg gave to the law school to display in the back there. If you go just outside the door from the Scalia statue on the other side of this, you'll see the eagle statue, which Greg Wyatt also had loaned to Harvard, but when we commissioned him to do the Scalia statue, he said that Harvard did not deserve the eagle statue and that it should come here. So you'll see a variety of things growing around here. We're excited about everything that's happening at the law school. I hope you will take time to look at the building. This is a break day for our students, so it's not quite as active, but I think tomorrow you'll see a very vibrant student body buzzing around, and I hope you'll interact with some of them when they're here. It's a wonderful group of students. The latest class is our best credentialed class in the history of the law school. We're delighted that the law school was just ranked number 30 in U.S. News and World Report, if you've not seen that development. So this is an exciting place to be, and it's exciting to have all of you here. So enjoy your break. We'll take 15 minutes, return at 9:30 for the second panel.